Bruce Tyler is the president and owner of Home Run Human Resources, and he owns, that's a human resource consulting firm for small businesses. And Bruce is pretty active in the community. He's a past president of the North Star SHRM and serves currently as their program director. He's treasurer of Beyond the Yellow Ribbon Steering Committee. He's a member of the Elk River Chamber of Commerce and a membership board member on the Minnesota State SHRM Council. Bruce is the past chair of Three Rivers Community Foundation, and he's past president of the Elk River Rotary Club, and he currently serves as a Taste of Elk River coordinator and a past president of the Elk River Area United Way. So Bruce is going to come up now and he's going to share with you on your rights as an employer. Let's welcome Bruce.
I started in HR in 1973 in St. Cloud at Fingerhut, and did, HR stuff for a couple of years, and then got promoted to training manager. Was probably the most significant thing that ever happened to me career-wise, because all of a sudden now I had to train every supervisor, every manager in the company on how to be a boss, how to give a performance review, how to discipline, terminate an employee, how to communicate with them, how to delegate projects, how to manage time. All the things that go into being a boss. I developed a curriculum and then taught that to every manager, supervisor in the company. Because think of it, prior to that, or prior to me coming, all interviewing, all hiring was done by HR. Back in those days, it was called personnel. Okay, so no manager interviewed or made a hiring decision. Then all of a sudden, we turned the table on them, and we're saying, we want you to do that. Mr. and Mrs. Manager, Supervisor. Now, you've created a monster where you have got to train everybody on how to be a boss, how to interview effectively, so that they're not breaking all kinds of laws and getting yourselves in trouble. So I did that for a number of years. Then started a progression of going to companies that were in trouble, cleaning them up, and then moving on to another one. I made a career of doing that. But now the last 10 years I have my own business. I concentrate on small businesses that don't have HR. And it's just a lot of fun. I'm really enjoying it. So anyway, that's background. How many of you own your own practice? Okay. How many of you that own it have at least one employee? All right. You have, I know you have an HR policy manual. How about you? Do you have an HR policy manual? Is it more than 10 pages? How many pages? 30? Oh, wow. Did you do it yourself? Okay, we need to talk. Okay. In my business and in helping with small employers, I come across all the time companies that they contact me when they get in trouble, and then I find out they don't even have a manual, or it's probably 20 years old, and that's not a good situation. In the material that you might have read on describing this class, it's titled Employer Rights. Now, we all know that you can, trip over yourselves and see employee rights everywhere you look. But employer rights, I Googled it, and the first 2 pages were employee rights. And I Googled employer rights. So I started listing them. I came up with 11, and then I did do some other research. I came up with, and found 17. And since I advertised it, I want you to all have this. Because I hear complaints from employers saying, I can't do anything. Well, you really can. You as an employer, you really have a lot of power. Just like the very first one says, you have the right to have a full day's work for a full day's pay. You have that right. If you have employees that are not productive, not putting out what they should be doing, what you expect them to do, then you need to talk to them about it and have them change their behavior or get rid of them. It's that simple. Any questions on any of the others? The second one, you have the right for workers to arrive on time, keep track of their breaks, and work right up until quitting time. Keep track of the breaks. Are employees entitled to breaks? How about it in Minnesota? Do employees get breaks? Are they entitled to breaks? What's that? 8 hours? She said with 8 hours of work, you get a half-hour break? Okay. Under Minnesota law, well, first off, paid breaks is a benefit, okay? Under Minnesota law, the only thing you have to do is allow an employee to go to the bathroom once every 4 hours. If they work an 8-hour shift, you have to entitle them, you have to give them time to eat a lunch. If it is 20 minutes or less, you have to pay them for that time. If it's more than 20 minutes, so normally it'd be like a half-hour lunch or hour lunch, that's not paid. But under Minnesota law, you do not have to give them a structured 1 hour or half-hour lunch break. So it's truly a benefit. Okay. Any questions, anything you want to ask on any of these employer rights? If you have your own practice, I encourage you to put this on the wall in your office and look at it. Because when you become frustrated as a boss, read this, and it might get your courage back. There is no state or federal law that says that any employer has to give holiday pay or vacation or PTO. Those are true benefits. There is no law anywhere that says you have to do that. Now, if you're saying that you do give some like vacation benefits, but you want to give some people more and some less, okay. If it's the same job category, let's say they're counselors, and you want to give them a little extra bump, you can do that. Counselors receive this. Office clerical staff receive this. But you treat them equally as a group, okay? There can be no differences within the group. But you can treat a group separately. That answer that? Okay. Yeah. Her question was, does it make a difference on the longevity of the person? Yes, that can be a factor, because in a normal vacation or paid holiday policy, there would be a progression of additional days, as time goes on. So there could be, but within the group, treat them all the same. Okay? Any others on this? I am really proud of this employer right thing. So you hang this up and and look at it occasionally. The question was, some places require applicants to pay for their own background check. There isn't any law that covers who pays, but personally, I think it would be kind of tacky to require the applicant to pay, especially if they didn't get hired. Okay, and by the way, on background checks, drug testing, things like that, if you do those, don't ever let anybody start work until you have the final result of that background check or drug test. There's nothing more embarrassing because you're in such a hurry to get somebody hired, to let them start work, and they fail the background check miserably or the drug test. And now you've got a real ugly situation. So don't let that happen. Don't let people start work until you have that. Okay. On the agenda, there were 4 points that I was going to be covering, and the first one is what is an employee policy manual, because really that is the reason why I'm here today. I said in the introduction or the published thing that's somewhere out there that if you don't have a policy that says that you can discipline an employee, if you don't have that, if you don't have a policy, you can't. You can't discipline an employee unless you have a policy that says you can. Otherwise, it's just straight out harassment, discrimination, God knows everything else, and you have no hope of winning. None at all. So what a policy manual does, and heaven help you if you don't have one, even if you have one employee, just one employee, you have to have a policy manual on how you deal with that one employee. Okay? So in Minnesota, there is a law that causes a lot of confusion. It's called the Employment at Will. Have you heard of that? Employment at will law in Minnesota means that an employer can terminate an employee at any time for any reason. An employee can leave at any time for any reason. All right? Now, for the employer, it makes you sound all powerful that you can do anything you want at any time. Just try it and see how far you get. You won't get far. If you're going to terminate somebody, make sure you have a good reason for it and then act on it, but just don't do anything like that willy-nilly. On the other hand, it irritates them. A lot of employers I know have policies that says employees must give 2-week notice if they're going to leave. There's no law that says that. Minnesota law says they can leave any time for any reason. You can request and ask that they give a 2-week notice or whatever, but you cannot require it. So don't even try. All right? Okay, so a policy manual really is just a guide. It's a rule book on how you as an employer are going to deal with the employees that work for you. That's what it is. It's not an all-encompassing book that covers all the operation aspects of your business. It's dealing with the human resource aspect, and that's what the manual is. And there's, unfortunately, many, many companies out there that don't have one and really need it. Now, what I would like is if we could take about 4 to 6 minutes, break into you 4 could be a group, and you 3 could be a group, and you 3 could be a group, and just kind of discuss what HR activity gives you the most difficulty. What HR activity gives you the most difficulty as an employer? Go ahead. You 3, you 4.
And she talked about some of the, you list things in your manual about dress or expectations, and they mean one thing to you and something to someone else, and just having to address those. And kind of in a Christian organization, sometimes it's expected that everyone's Christian nice, and so when you have to discipline, that becomes, they feel like that is not Christian nice.
One of them was not having a full-time HR person or an HR expert on staff, just being unsure about how decisions we make, whether those are in compliance with labor laws or not. So we don't have a resource on staff, so we end up Googling it or whatever. So.
That's a very good point. In fact, my clients are very small, that none of them have an HR department. I tell my clients, please don't discipline or terminate an employee until you call me. Test it out on me. If I buy into the discipline or the termination, then go ahead and do it. Otherwise, I will warn you not to. In fact, that brings up, thank you very much. We'll get to you in a minute. Brings up the difference. I'm going to talk about David Monroy, who was here earlier, who's an excellent lawyer. In fact, I use him for employment dispute stuff. But the difference between a lawyer and an HR person. An HR person will keep you out of trouble. But if you get in trouble, you have to have a lawyer to get you out of trouble. HR people are not going to get you out of trouble. They'll keep you from getting into trouble. That's the difference between the two. So you need a good HR person and you need a good lawyer. You need one of each. Okay, so a reporter from that one, come on up here.
We talked about the challenge of enforcing that discipline, especially when you like people and you're trying to cultivate that, friendly atmosphere, but when it's smaller issues like being consistently late.
The 80-20 rule, this is a fact of life in corporate America, all over the place, even in your places of business probably. 80% of the time that a boss will spend on their employees, 80% of that time will be on the bottom 20% workers. That means you are spending 20% of your time on your top 80% employees. Your very best employees, you're virtually ignoring. And what does that tell them? What does that tell your best employee when you don't even talk to them? They get frustrated and they leave. Happens all the time, every day, all over America. And I tell you, if you have a fair number of employees, you need to identify, rank them in terms of their productivity from top to bottom. And who is the lowest? Do not give that person 80% of your time. Talk to them, get them to improve, or they're gone. Right? That's how it has to be. It's your business. They make money for you or they cost you money, one or the other. And it's a lot more fun to have them make money for you. And those of you who actually have your practice, I'd be willing to bet that you can admit that you have spent a lot of time agonizing over the activities of an employee that shouldn't even be there. Right? It's true. Happens everywhere. Okay. Now, what should be in the manual? Types of things. I'm not going to give you a list on that because then I'm giving away all my secrets and then you don't need me. So I'm not going to tell you that. But I mean, we will talk about a lot of them, but not all of them. Okay. In Minnesota, there are a number of state laws that they're statutes, and they are rights for employees, and it is the employer's obligation to notify employees of these rights. And the best vehicle to do that is to put them in a policy manual. That's the best place for them. I'm not going to cover these in detail, but just school conference, activities leaves. That's a certain amount of time that employees can take in a calendar year to go see a child's play or sporting event or something like that, during the workday. And they're not paid for it. Time off to work to serve as an election judge, that's just for old people. Time off to vote. I want to talk about this one for a minute because this is an election year coming up, okay? What is your understanding, so that you have your practice there, of what your employees can do on election day? Minnesota law says that an employee can leave at any time to go vote, and it will be paid time. If they get up at 11 o'clock and say, I'm going to go vote, and they don't come back until 1:30, that's 2.5 hours paid time. And they say, well, the lines were long. And it just irritates you to death because the polls open at 7 and they close at what, 8? Something like that? Well after, end of work time. And you think to yourself, why can't you go vote before work or after work? Why can't you do that? You think that. Don't say it. All right? Keep your mouth shut. Just bite the bullet, pay them the 2.5 hours, and you don't have to worry about it for another 2 years. Okay? It's Minnesota law. Because I guarantee you that if you make a sarcastic comment or a judgmental comment about that was poor taste to go vote, and anything bad happens to them in the future, that's a retaliation charge. And you've lost. You just did that to me because I went to vote. Right? So be careful of that. Just bite the bullet and let it happen this year. Nursing mother, that's a Minnesota statute. In fact, it got revised a year and a half ago to make it even better for nursing mothers. Wage disclosure protections. This is cute. One thing that grates on employers sometimes is when employees are talking about comparing wages of what they make. They stand by the water cooler. Hey, how much money do you make an hour? Okay, and that irritates employers. Well, National Labor Relations Board has come down and said that's legal. If employees want to stand there and compare wages, how much you make, how much I make, they can do that. They have that right. In fact, it's now written into Minnesota law under wage disclosure protections. Employees have that right to discuss their wages. Just bite your tongue. Okay, so sexual harassment is a Minnesota law. My policy, I call mine offensive behavior because there's a lot more awful things that an employee can do besides just sexual harassment, so it's more encompassing. But here's the thing about sexual harassment. Minnesota law says that every employer, if you have one employee, has to have a sexual harassment policy. And you have to provide training. The courts have ruled that if you have a policy and you don't provide training, it's as if you have no policy. So you have to provide training. The statute does not identify what training means. But law organizations, like ones that David might belong to, have agreed, and courts have agreed, that basically 2 hours every 2 years. So 1 hour a year. So I recommend to my clients, take the offensive behavior policy, get all the employees together once a year for 1 hour, and read over the policy and talk about it. Have them sign a form that says sexual harassment training on this date, and put it in a file called sex harassment training. Done. Do it next year for 1 hour. So without the training, it's as if you don't even have anything. You have to provide training. I advise all my clients to have a jury duty by statute. If a person is called for jury duty, employer has to let them go, okay, at no fault. Just a little side opinion, soapbox rant on my part. Do you remember the smoking case about, I don't know, 10, 20 years ago in Minneapolis? It went on for a year almost, on smoking. They were suing the big tobacco companies. Does that ring a bell? Okay. Do you know that there were 3 of the jurors that they foreclosed on their homes because they could not work during that time? They could not make house payments. 3 of them lost their homes. And personally, I think it's just a crime. I think if we're going to have the system we have in this country to, courts and juries and all that kind of stuff, if we expect private citizens to serve on juries, they should be paid. I don't care where the pay comes from, but they should be paid. That's just me. Okay, whistleblower is a state. It's also a federal law. Whistleblower is if you're an employee and you tell your boss, look, we are doing something illegal, and the employer shuts you up or fires you or something like that, you have protections, for reporting a wrongdoing. So that's basically what that is, and that's both state and federal law. The military leave, that's pretty standard. That's a federal law, and so if you have an employee who goes into reserves or goes overseas, they have some protections, and that gets reviewed fairly often and gets modified. So I try to keep the policy vague, just that you will comply with it. Beyond that, we get into larger employers. Just speaking of that, do you have in your practice, do you have posters up? The required posters. Where'd you get those? Online. From where? Did you pay for them? Well, good. I'm proud of you. Yeah, they are free. Just earlier this week, on Monday, a client asked, they were offered, some company was offering them their posters for $230. Yeah, I said, no, tell them no. And so I gave her the website. We went online, bingo, printed them off for free. But there are plenty of employers and my own clients who sometimes, even after I give them the right posters, get convinced to buy these slicky things. You've seen them on the walls, okay? They have every poster on there. Have you ever heard of FMLA? Family Medical Leave. Does that apply to you? Does that law apply to you? Do you have to comply with that law? That's my question. Who says yes? Wrong? Huh? Yes. You have to have, when an employer gets 50 employees, they have to comply with that law. If you have less than 50 employees, you don't have to. But here's the thing. These slicky posters that they sell you for $230, and they have all of them on there, the FMLA is right there. As an employer, if you post the FMLA poster on your wall, you are telling the world, there it is, and we're going to comply with it. You will be expected to comply with that law if you post it, even if you only have one employee. So don't post it. So we've taken many X-Acto knives and cut that one out. So there are others too. You know, there's a whole number of federal laws. I'm not going to, most of them I'm not even going to cover, but a couple I'm going to because they're relevant. Is it common in your industry to have independent contractors as employees? It is? Okay. This is now we get into the difference between HR and lawyers. I would suggest that if you have contracts with employees, or if you have independent contractors, if you're calling them that you talk with your attorney. My suspicion is that they should be employees. It is getting tighter every year, what the government is doing to make employees true employees, W-2 employees. They want them to be W-2 employees. And it's getting tougher to be an independent contractor. It really is. Because if you're controlling what they're doing, when they're doing it, and where, they're an employee. Pure and simple. If you have contract employees, you lose the employment at will. That's gone. You know, that's like you've created your own union by having contracts. So I'd stay away from contracts too. Contracts have time limits, and you can't, that's a contract, can't break it. Okay. You had a question? Oh, sure, it usually does. Yeah. It will, but I'm not claiming to be an expert on the aspect of independent contractors or contracts. If you have those issues, contact your attorney on that. I don't want to mess with that. That's too legal. Besides, you might already be in trouble. Who knows? And then that gets in the whole issue of non-exempt versus exempt employees too. Exempt means that they are exempt from their Fair Labor Standards Act. They're exempt from those laws. It doesn't apply to them. Exempt employees are usually managerial, professional type employees. Non-exempt, they're not exempt from the law, the Fair Labor Standards Act, so that means the law applies to them. These are your hourly workers, clerical workers, things of that nature. Okay? I had a client a few years ago was complaining because he didn't like to pay overtime. And he was blaming President Obama for having to pay overtime to employees. And so he was being very critical of him. And so he thought President Obama had created overtime in America. And I said, do you know when that started? And he said, with Obama. It was 1938. That's when that law went into effect. I don't think Obama was born then. So, so you've got to be very careful on the exempt, non-exempt rules. That falls in the same category. If you have issues on that, if you have suspicions whether a person is, whether they're exempt or non-exempt, they're probably non-exempt. Okay? Lean on that side. Okay, that's all of the federal ones that I wanted to talk about. Um, some other policies that definitely should be in a manual um, is constructive discipline. And in the old union environment in America, union contracts had what was called progressive discipline. You heard that term? And what that means is that something happens and you get a verbal warning. And then it happens again, you get a first warning, or maybe a final warning, and then a termination. Progressive. Okay? And they were real strict on that. So it's like, you take a big wad of bubble gum and rub it in somebody's head, and you get a verbal warning for that. Does that mean you got 2 more shots and then the next one you're going to be terminated? Discipline really can start at any step of the progress, of the process. Do not use the words progressive discipline. Do not use those words. Depending on the seriousness of what a person does, depends on where you start in your process. You may start at a verbal warning, but a verbal warning is really kind of stupid because it has to be documented, because if you don't document it, it didn't happen. You know that. You know all about documentation, right? There's no verbal stuff in your business. It's got to be written down. Same thing with discipline. Even if it's called a verbal warning, it's got to be written down. You could start at a first warning, a final warning, or you could start a termination because it's serious enough. So a good discipline policy has to allow that to happen, that it can start anywhere, okay, depending on the seriousness of it. And by the way, since we're talking about discipline, let's say that you were going to terminate an employee, and the employee is about to walk into your office to receive that termination, and how much time goes by the time the employee gets up to leave? How much time does that termination process take? On average, how long should it take? Just shout out a number. How many minutes or hours, whatever? 5 minutes. Do we hear 10? Huh? Any other numbers? 12. Okay. The right answer? 4. 4 minutes. Any termination that takes longer than 4 minutes, you have failed. All right? If you're going to terminate somebody, you have their last check ready. You have everything. You have all the documentation there. You got everything ready. They walk in, and you tell them, you just open right away that we've decided to terminate your employment effective today. Here's your paycheck. I need your keys, blah, blah, blah. Usher them out. Gone. 4 minutes. Cannot be any longer than that. The longer you stay in that room with that person, they get angry. And you don't want to be in a room with angry people. In fact, if you terminate somebody, I always advise my clients, try to have them outnumbered. So have 2 of you in the room. So, any questions on that? Okay. Overtime, of course, has to be in there. Minnesota has a stupid law. Sorry, I love Minnesota. Overtime law that says that employees get overtime after 48 hours. Now, you know the federal law is 40, right? Federal law is 40. Minnesota has a law that says 48. I have clients that tell me, why should I pay overtime over 40 when Minnesota law says 48? Well, there are provisions in there. And one of the provisions is called, if you exercise interstate commerce, you have to comply with federal. So what is interstate commerce? If you make or receive a phone call, business-wise, from another state, it's interstate commerce. If you receive or send a letter to another state, it's interstate commerce. If you can honestly say, I have never done any of that. What roads did you drive on to get here today? Were any of them I-94? That's an interstate. If you drive on an interstate, that's interstate commerce. So why they just don't get rid of that law is beyond me, because it doesn't apply to anybody. So forget it. Don't fall on that. We talked about working our rest breaks, meal breaks. It is state law that you have to give an employee a restroom break once every 4 hours. You have to, if they work 8 hours or more, you have to give them a meal break. If it's 20 minutes or less, you have to pay for it. If it's more than that, it's non-paid. Okay, now we're going to have another exercise. You four, a group, you three again. And did you lose somebody? Okay. Oh, his jacket's there. Okay, here's your assignment. How would you handle an employee who shows up for work drunker than 4 goats and is snorting cocaine right there in the lobby? That's how they show up for work. How would you handle that? Discuss that amongst yourselves. How would you handle an employee who shows up for work drunker than 4 goats and is snorting cocaine?
Well, I think the first piece was, our ethical codes indicate that they can't do service to someone while you're impaired as a therapist. So it's an immediate suspension for the day, and then continue to look at whether or not that suspension turns into termination, depending on whether or not they get treatment for.
So suspended for the day
Yeah.
and possible termination.
Yeah.
Okay. All right.
Well, as an employee, I would ask them if they were intoxicated and if they'd be willing to submit to a breathalyzer or UA, and then if they obviously have to not work for the day and make sure that they get transportation either to home or even detox if that's what they choose.
Better answer.
Well, kind of similar answers, I guess, as the rest of you. We talked about it might make a difference depending on if the person was a therapist versus a support staff person in terms of the action that you would take. So if it was a therapist, we would need to contact their licensure board because they're impaired in their ability to provide services. And so there'd be other steps we would need to take. But we might not necessarily fire the person. It might need to be a conversation about a willingness to seek treatment and get the help that they need so that they could continue to work for us. But there would have to be specific guidelines, and everything would need to be documented very clearly.
Yeah. Under Minnesota law, in that situation, if that was, the first time, never happened, there was never inkling before, you could not fire that person. You can. Alcoholism in the state of Minnesota, or even a drug addiction, is considered a disease. And you cannot fire someone for having measles or mumps or being drunk or on drugs. You can't do that. Unless, first step is they have to get a chemical assessment by a professional to determine if and what kind of problem they have. As an employer, you have to offer them if they refuse the assessment, you can fire them. If they go through the assessment to determine whether or not there's treatment involved, if they take the treatment, great. If they refuse the treatment, you can fire them. If they finish the treatment and sometime later it happens again, you can fire them. Okay. So you do have rights, but certain things have to happen. So you just can't react willy-nilly. And so what I like to have my clients have a drug testing facility card that is capable of working on a 24-hour basis, so that in a situation like that, somebody mentioned getting them transportation home. Oh yeah, you did. Not you, or not anybody else. That drug testing company that will come in on a moment's notice, they will take care of that. Not you. Don't take care of any transportation. Yeah. Yes and no. If they have a drug testing policy, then it would be expected that the assessment would be through the company's drug testing resource. If at a, I'll get to this in a minute, but at a minimum, there has to be at least a drug-free workplace policy, which provides to handle this. So you might have to, if you don't have one on hand, you might have to call one, but the employee's going to have to pay for it. You don't have to. In Minnesota, there are 4 reasons why that you can test for drugs. One of them is for new employees, all new employees. A lot of companies have that. Reasonable suspicion. That's a very common one. You know, if you expect that they're impaired to some degree, that's why you need a relationship with a good drug testing company, that they come in and do that testing right there in your building, right now. The third one is a work comp accident, and the fourth is random. Random is, I have clients that say, oh, I want to do random testing, but I'll pick them. Sorry, that's not random. The way random works is that if you're going to do a random selection of a certain number of employees every certain amount of time, you know, like maybe 2 employees every 6 months, as an employer, you submit all of the employees' names to the drug testing company. They randomly, truly random, pick 2 names, if that's what you've agreed to do, and those are the ones tested. And then the first time it happens, hope like all get out that it's the most elderly grandma that you have in the place. Then they know it's legitimate. So, or maybe, I don't know, who knows? Maybe they do it and we don't know. So, but you have to be careful. Random is not who you think of. It's truly random. I recommend at a minimum all my clients to have reasonable suspicion and work comp accidents as the 2. That's what I call drug-free workplace. That's what you have. So have that. I don't think, you know, if you want to go further than that, have all new employees or do random, it's up to you. You'll have to pay for that test. I would use the reasonable suspicion based on their behavior, not on their paraphernalia that you find. You could ask them and say, is that yours? How'd they get there? You know, that looks pretty weird for somebody in your position. So, but I wouldn't make a huge deal out of it, except just make sure it's noted that they know that you know. Okay. But base any of your actions on their behavior. That's the determining factor. Okay. Enough on drugs, all that kind of stuff. You guys know all about this stuff anyway. Alternative dispute procedure or resolution procedure is one that I recommend that all clients have. What it is that employees basically sign away their right to sue you. That's what it is. All governmental agencies, whether it be federal, state, county, city, schools, they all have that policy. Every single one of them. Every major corporation in America has that policy. Everybody has it, except small employers. And guess who needs it the most? You do. You're one lawsuit from going out of business if you lose. So you need that protection. And unfortunately, with that policy, if you have an existing company or practice and you say, oh, I want to implement that policy, you can ask existing employees if they will sign the form, but they don't have to. All new employees must sign the form or they can't work there. But if they're existing, you can't force them to sign. It is, in fact, a good deal. It really is, because the average lawsuit in this country can take years, 3 years to get to trial. Okay? And in that time, if there's this case where it's them against you, it just gets uglier and uglier, and the lawyer fees mount up as the time goes on. And it just gets worse and worse. With an alternative dispute resolution process, I give two choices in my policies, the AAA, American Arbitration Association, and the second choice, David Monroy, who was the last speaker. I use him. He's a tremendous mediator, very good. And so I use him. He's part of the policy. And it will get over fast. If you can't come to an agreement, even through discussion or mediation, it will go to binding arbitration with David, and there'll be a winner and there'll be a loser. And you could be the loser. Okay? But it'll get over with quick, and you can move on with life. So that's why it's a good deal. It really is. Okay. Now, I want to talk about that was the list that I wanted to cover. How to implement the manual was the fourth item. When you get a new manual or a revised manual, print out copies for all the employees, give it to them, tell them, read it over, mark it up, and we will all get together next week or 2 weeks, and we will discuss any questions that you have. And do that, answer them all, and you, as the as the owner of the business, you will have to explain every policy if necessary, and say what the intent of this policy. This is what it means. And by the way, I never mentioned this before. Policies are best written when there is an element of vagueness. That sounds crazy. Just take a discipline policy. I one time had a client years ago that tried to list, they had a 20-page discipline policy list because they tried to list every bad thing a person could do. Well, that can't be done. All right? Anything that's not on the list apparently is okay. So a good policy is tight, but it's got some looseness to it, and it is subject to interpretation. And who is the interpreter? The owner. They're the interpreter. So, anyway, I don't know where that thought came from, but it did. So, anyway, implementing the manual. So then you get back together and you explain everything all, and then you're going to give them the form, the acknowledgement form, that I have received the manual, I have read it, I understand it, and I will comply with it. And they sign their name, and it goes in their file. Okay? And if they refuse to sign it, they're gone. They have to sign that form. You have to get them to agree that they will abide by that policy manual. That has to be done. Okay. And then the last item is how to forms to operate your business. I want to talk about the employment application first. Last year before, Minnesota legislature had what was called ban the box. Have you heard that phrase? Okay. What it is, on employment applications, there was always a question that's asked, have you ever been convicted of a felony? What was it? When did it happen? Blah, 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 right? You've seen that. Okay. With the new state law in the state of Minnesota, ban the box. So the box on felonies in the employment application is gone. It's gone. So if you have an employment application and that question is there, black it out and don't have them answer it. Now here's what it all means. Since you don't know if they committed a felony when they apply for the job and filled out the application, and you invite them in to be interviewed, when they come in to be interviewed, you give them another form. And the forms ask for a listing of any felony convictions in the past. You know, when, what it was, and all that sort of thing. And then you see that, and if it's terrible enough that, they had just recently gotten out of jail for embezzlement and you're considering them to be a bank teller, you may want to just cancel that interview at this point, because that's just not going to happen, or hire them as an accountant. But what it does, it prevents many, many employers who basically discriminated against people who had felonies and wouldn't even bother to interview them or even invite them in the interview. Well, now they're physically standing in front of you. You might as well talk to them, unless it's so terrible that you just can't ethically hire them for this job because of that felony. So it really helps past felons. It's a good law. It's a good law. But here's the thing. If you have hired people in the past, did they usually provide a resume? You all have resumes, right? Is your resume totally 100% accurate? You don't have to answer this. Is it 99% accurate? Man, we could go down on the numbers. Virtually, almost all resumes in America have some falsehoods in them. There is no penalty for lying on your resume. You can make it as good as you want. But if you lie on an application, an employment application, like that, if you lie on this, and 20 years from now, I discover that you lied on this application, I can terminate you 20 years from now for lying on the application. This is a legal document. You cannot lie on this and expect to get away with it. My application is 4 pages long. This is the last page. It has every protection known to the human race on this page. Right there. And if they sign their name on the bottom, of which if they have to, or they don't get hired, they are agreeing to everything on that page. Okay, if you didn't hear it, is it routinely done to do background checks on applicants? Yeah. Well, I have kind of in your business, I would do background checks. Now, regarding background checks, you can go on the internet and you can get some free background checks, but you know it's a classic case of you get what you pay for. The information out there is old, may not be accurate, may be a different Bob Jones, who knows? But you get what you pay for. So if you're going to really do a background check, I would hire a legitimate company. And you're not doing background checks on everybody who applies for the job. You're only doing the background check on the person you're going to hire. And this is what you say to them. We are offering you employment contingent on a successful background check and or drug test if you're going to go that route. So you're really only doing it on one person. You're not doing a background check on everybody. If you want to do the free ones, I don't care. I wouldn't advise it. There are a lot of good background checking companies right here in Minnesota that are, and now with the way they can do it, they set up the system on your computer so you can do it right from your office. You can do the background check yourself, but they set up your computer to be able to do that. So you're doing it, and so it's almost instantaneous. The only thing that takes a little longer is for a county courthouse. That can take 24 or 48 hours sometimes. Did that answer that? Okay. So, for your benefit, don't stop using resumes. Resumes are a real good thing to get good information quickly and get a general feel of a person. But always have them fill out an employment application. Okay? I mean, that's just critical. That needs to be done. When you do hire employees, there are some, you know, the federal law, you've heard of the I-9, the immigration law. That's a form that employees have to fill out within the first day or so of employment to prove they're legally able to work in the United States, okay? That's got to be, that's federal law, and the fines are brutal if you as an employer don't have that done. So make sure it happens. If you haven't done them, see me, see me, and we'll get you caught up to date. And of course, you know, new employees have to get a W-4. And then Minnesota has a law, this new hire reporting center. What that is that when you hire somebody, you have to go to this website and report that you've hired so-and-so employee, and you know, you provide a little information. What it is they contact all, what is it, 87, 86 counties? How many counties in Minnesota? 87? There's a whole bunch of them. They contact every county in the state to find out if the person you've hired is obligated to give child or spousal support. And if so, they'll notify the county will notify you, and then everything's hunky-dory. There'll be deductions made from their paychecks to pay their obligations. So that is a state law that has to be done. Yeah. New Hire Reporting Center. You can Google that, put Minnesota New Hire Reporting, and you'll get the website. It would. Oh, and by the way, on I-9s, if you have, when they fill it out, do not put it in their employee file. Have a separate file called I-9s. So all I-9s are in one file, because government inspectors like to come, and if they come, and they could, very well could, to inspect your I-9s, if you're storing them in their individual employment file, then they can look at that file, everything in that file, and find other things questionable. So I have all the I-9s in just one file. I've told you everything I know. I don't know anything else. I have business cards if you want one. But we're done. And thank you for listening and asking good questions. I had fun.
Thank you, Bruce. I'm just going to vouch for the work that Bruce does. He actually helped us create our employment manual for Hardy and Stevens, and he's been a great resource for us to be able to refer to with HR questions when they come up, because we're just not big enough. A lot of us little guys aren't big enough to have an HR person on staff, and we're not trained in HR, and so there's challenges with that. So thank you for sharing your wisdom with us.